Hello, everybody. It is 2 o'clock now, so I think we're going to go ahead and get started. I am Mariana Almanza Cook. I'm Director of Business Retention and Expansion for the Woodlands Area EDP. I'd like to thank everyone for taking time out of their busy day to join us for this virtual HR forum series. And we'll be covering a variety of important employment law topics. Today's webinar will be recorded, and we will be sharing it as a resource with all of our major employer contacts. We've chosen to present this today in a webinar format, which means that our attendees will be able to participate anonymously. So please feel comfortable to add your questions for our presenters in our Q&A box throughout the meeting. I'd like to begin by introducing our moderator for this session, Holly Gurry. Holly has been with the Woodlands Area EDP since 1999. She serves as our Chief Operating Officer. In this position, she's responsible for day-to-day operations of the organization, which includes managing the organization's staff, budget, accounting processes, and functions. She also serves as our HR administrator, which is why I've asked her to participate in this forum today. Thank you, Holly.
Thank you, and hello, everyone. As Mariana said, I'm Holly Gruey, Chief Operating Officer for the Woodlands Area EDP. Thank you to our presenters for covering today's forum topic, Return to the Workplace, Preparing for OSHA's Emergency Temporary Standard Mandating Vaccines. Josh Redelman and Morgan Munoz are both associates at one of our valued partner organizations, Stibbs & Co. Attorneys, and they specialize in the practice of labor and employment law issues. And we really appreciate them and their presentation that they put together for us today. And with that, I'm going to go ahead and pass the mic over to Morgan and Josh.
Thank you, Holly, for that introduction. As Holly said, my name is Josh Redelman, and I'm a labor and employment lawyer at Stibbs & Co. I'm joined here with my colleague, Morgan Munoz. And I really want to thank the Woodlands EDP for providing us this platform to speak with you all today. It's my hope that each of you will be able to take the information that we share and put it into practice. Each of you face a unique challenge, whether you're in the healthcare, energy, local government space. Regardless of your industry, you face challenges presented by the Biden administration's forthcoming ETS. And how you deal with that is going to be unique to your workplace. So Morgan's going to kick it off now and talk to you about the history of vaccine mandates, how the EEOC has advised employers mandating vaccines up to now with the COVID-19 pandemic. And she's also going to discuss some recent cases on the issue. So we'll pass it over to my colleague, Morgan.
Hi, thanks everybody for joining. So very early into the pandemic, the EEOC, they began issuing technical assistance questions and answers to address ADA and COVID. And so we have been advising employers how to navigate the ADA and COVID based on the EEOC's guidance. And so the most hotly contested issue has surrounded the implementation of mandatory vaccine policies, which is a lot of what we're here to talk about today. So the EEOC has said that COVID-19 poses a direct threat to the workplace, but they have also said that EEO laws do not prevent employers from requiring employees who enter the workplace to be vaccinated against COVID-19. The one consideration that you have to have if you have these mandatory vaccine policies has to do with the request for accommodations under the ADA and Title VII. So best practice, if you have these types of mandatory vaccine policies, is you should inform employees when you're implementing them that they may make a request for reasonable accommodation if based on a disability or a sincerely held religious belief. So you should educate your managers of what to look out for when people raise these types of requests. The employee doesn't have to actually mention the words ADA or Title VII, and their request does not have to be in writing. So going specifically to COVID vaccine exemptions and the issue of somebody making a request for an accommodation based on a disability, if an individual poses a direct threat to the health or safety of others and the threat cannot be reduced by a reasonable accommodation, then the ADA protections, they do not apply. So if somebody approaches you with a request for an accommodation, as with any other ADA issue, you need to engage in the interactive process to determine if you can provide a reasonable accommodation that wouldn't pose an undue hardship on the employer. And under the ADA, undue hardship is defined as a significant difficulty or expense on the employer. So if somebody asks for an accommodation request, the employer is permitted to verify, one, that the employer has a disability, and two, that there's an available reasonable accommodation that can be offered. And so the EEOC guidance on some permissible questions that you can ask surround how the disability creates a limitation, how the requested accommodation will effectively address the limitation, whether another form of accommodation could effectively address the issue, and how a proposed accommodation will enable the employee to continue performing their essential job functions. So some examples of some accommodations you can provide include providing PPE, like enhanced protective gowns, masks, gloves, separating those immunocompromised employees from the rest of your workforce. If only marginal job duties of theirs involve interaction with people, you could replace or substitute some of those job duties. You can also modify their work schedule. And then one of the biggest things that we have a lot of questions about that comes up has to deal with the telework. And so in terms of pregnancy, I just wanted to touch on that. The CDC has come out and said that it recommends that pregnant women have the COVID vaccine, but this can be obviously a touchy issue. So if somebody approaches you, my recommendation, if they're wanting an exemption based on pregnancy, is to treat this just like any other ADA type request and to engage in the interactive process. And another issue that comes up in the ADA context has to do with long haul COVID symptoms. So this is something like if somebody contracts COVID and they have lung damage or cardiovascular issues, anything like that afterwards, that also can implicate the ADA. And so again, just as with any other ADA issue, engage in the interactive process. The exemption I mentioned before about sincerely held religious beliefs under Title VII. So the EEOC cautions employers to start from the presumption that an employee has a sincerely held religious belief if they are requesting an exemption based on their religion. The employer is permitted, however, to ask additional information if they have an objective basis to question the sincerity of the belief. There's also an undue hardship standard under Title VII, but I would say it's less rigorous for employers to meet. It is defined as having more than minimal cost or burden on the employer. And if you contrast that to the ADA, which is causing significant difficulty or expense. And so one of the issues in this that comes up, or that you might have heard on the news, a commonly raised objection, has to do with fetal cells and the research and development of mRNA vaccines. And so, for example, the Pope has come out and said that he supports vaccines and he's encouraging people to get the vaccine. So an employer might be tempted, if a Catholic person comes and says that they have an objection based on that, to question the sincerity of that religious belief. But I do want to say that the U.S. Supreme Court has said that questioning the sincerity of someone's religious belief isn't within their jurisdiction. They're not going to scrutinize whether or not somebody's correctly interpreting their faith. And so interfaith differences are common. So just tread cautiously and start with the assumption that this is a sincerely held religious belief. But it should be noted that Title VII doesn't protect against political or philosophical type objections. And so it's important to separate that. So it's kind of a complex analysis that you have to go through. But just being opposed to vaccines in general doesn't qualify as a sincerely held religious belief. One interesting case that has made national headlines is this Houston Methodist case. It's a recent lawsuit that was brought against Houston Methodist Hospital in Houston, the Woodlands. And the issue was testing the lawfulness of mandatory vaccine policies. So 117 hospital workers, they sought an injunction to block the policy. And their two main arguments was that these vaccine policies are tantamount to mandatory or to a wrongful termination. And then the second argument was that it's against public policy. And so the Southern District of Texas, the federal court, they dismissed the lawsuit. The first issue, the wrongful termination issue, Judge Hughes starts his opinion by saying that he is not going to analyze the safety and efficacy of vaccines. That's not part of his judicial analysis. The issue of wrongful termination in Texas, it's not a cause of action that you can bring except if the employer orders you to commit an illegal act and you refuse to commit the legal act. So he said that vaccines don't have anything to do with illegality. The employer is not ordering you to do anything illegal. So the wrongful termination, which is a narrow exception to the at-will doctrine, doesn't apply. And then he also cited he cited a 1905 Supreme Court case. And so this 1905 Supreme Court case, it tackled the issue of state-imposed requirements for inoculation. And so he said, based on that and the EEOC guidance that permits employers to require COVID-19 vaccines, the legal precedent doesn't support imposing this injunction. And then the other argument was public policy based. And the hospital workers argued that federal law prohibits mandates to receive unapproved vaccines, and that this is tantamount to requiring employees to be human subjects, violating federal law, which requires informed consent to participate in medical studies. And so Judge Hughes, again, he said that the FDA doesn't create a private right of action against an employer. So the fact that this vaccine is not FDA approved is relevant, and that these hospital employees are not participants in a human trial because the hospital is not actually testing the vaccine on its employees. And then the other argument they raised actually was the Nuremberg Code, and they analogized the threat of termination to forced medical experimentation during the Holocaust. And Hughes was offended by this type of argument, and he said that equating the injection requirement to medical experimentation in concentration camps is reprehensible. And so he said, additionally, the Nuremberg Code, it does not apply to private employers, it's only to the government. And the crux of what Judge Hughes' argument was, it fell back on the at-will employment doctrine. So basically his main point was that employers can set conditions of employment and the employee can choose to work elsewhere. So Methodist, he said, is trying to do their business of saving lives without giving them the COVID-19 virus. So he rejects that employees are being forced or coerced into taking the vaccine, because the hospital staff can freely decide to refuse the vaccine and work somewhere else, just as with any other type of employment condition that the employer sets. And then the 1905 Supreme Court case, I just wanted to touch on that again. So this isn't the first time as a nation that we've dealt with state-imposed vaccines. The Massachusetts Board of Health, it mandated the smallpox vaccine during the smallpox epidemic. And in this case, Pastor Jacobson, he refused the smallpox vaccine, arguing that he and his son had previously been injured by vaccines. And the Supreme Court here, they said that it is within the police powers of the state to enact a compulsory vaccination law. But it's important to note that this Supreme Court case, it did not deal with the issue of whether the federal government can control the epidemic. It was only dealing with a state issue. So that wasn't the contested issue in this had to do with whether or not the state had exceeded its powers under the 14th Amendment due process clause. But interestingly, Justice Harlan in this case, he did kind of make a comment that he's not going to say, or they're not going to establish that there's an absolute rule for a vaccine in all circumstances, that if you can show that with some reasonable certainty that someone can be harmed by the vaccine, that might be a reason to not impose the vaccine. And with that, I'll turn to Josh to talk about OSHA.
Yeah, thanks, Morgan. And thanks for your presentation on the kind of the history of the vaccine mandates and the interesting arguments presented in those cases. I think it's really important for the folks listening to understand kind of the background for where we came from to where we are now. So I want to talk a little bit about OSHA so that you all understand OSHA's history, its authority, and how it plays a role into why we are here today and why President Biden actually selected OSHA rather than some other agency to put forth this emergency temporary standard. So what is OSHA? For those in the audience that aren't familiar, and there's a lot of folks in HR and in the executive level folks that don't really understand what OSHA can do. So OSHA has been around since 1970. It's the Occupational Safety and Health Administration, and it was created by the OSH Act. I'm just going to call it the OSHA Act. So under this law, Congress has said employers have the responsibility to provide a, quote, safe and healthful workplace that is free from serious recognized hazards. Well, that's really, really broad. And the reason for that broad charge is that Congress has delegated its authority to regulate the workplace to OSHA. And that is how OSHA gets its power. OSHA has broad rulemaking authority because it derives its authority from the Commerce Clause. And for the constitutional scholars in the audience, the Commerce Clause is Article 1, Section 8, Clause 3. And what this section has been read to do is give Congress the power to regulate commerce with foreign nations, among the states, and with the Indian tribes. So if you're thinking, wow, this is really broad, you're right. And if you want a case to really see how broad this is, you should check out the Wickard versus Filburn case from 1942. It's a Supreme Court case that essentially said Congress had the ability to regulate how much wheat a subsistence farmer grew on his own property that would never go out. He was not selling it. But the Supreme Court in that case said Congress could pass a law that tells a subsistence farmer how much wheat he can grow on his own property. So that just kind of gives you a little bit of background, but I don't really want to spend too much time in the Commerce Clause because we can talk about it for hours. And this is not a webinar on the Constitution. It's a webinar on OSHA and vaccine mandates. So what does the OSHA Act apply to? Well, it covers almost every single employer, private employer in the United States. There are 4 entities or 4 categories of employers and employees that aren't covered by the Act. 1, folks that are self-employed. 2, immediate family members of farm employers. So husband, wife, kids of folks that have dairy farms, cattle ranches, et cetera. 3rd, workplaces that are regulated by another federal agency. So for example, I'm from West Virginia, a lot of coal mines, and OSHA doesn't regulate what goes on in a coal mine. MSHA does, which is the Mine Safety and Health Administration. So the Department of Energy also has some regulatory authority on what goes on out at oil rigs and et cetera. And then the 4th category is if the state that you're operating in and where you have employees, where you're operating, if the state has an OSHA approved program, then the state and local government agencies, the employees for those agencies are not covered. And so as you can see on the slide, Texas is a federal OSHA state. So what that means, and there's only 22 other states, there's only 22 states in the United States that have state approved OSHA plans. But what that means is what the federal government says about what has to be done in the workplace in Texas, that's what Texas employers have to follow. So now that we have a kind of a background on what OSHA is and where it derives its power, I want to talk about the typical OSHA rulemaking process. And as you can kind of see here on the slide, it takes a long time. Stage 1 is typically 12 to 36 months. And that's time that OSHA and its regulatory folks at the agency spend identifying what the health and safety hazard actually is. They do research. They meet with stakeholders, meaning you, the employers. They meet with union reps. They spend up to 3 years actually deciding whether they want to regulate or not. So adding this all up, you can see in the typical rulemaking process, typically takes around 8 years. So this emergency temporary standard that was announced in September, as you can see, it's a deviation from the norm over at OSHA. So now I want to talk about kind of what is an ETS? What is an emergency temporary standard? So an emergency temporary standard is essentially a rule, just like any other regulation that comes out of OSHA, that OSHA publishes in the Federal Register, and it takes immediate effect upon approval from the president. and it remains in effect until it's superseded by a permanent standard. Now in practice, what that actually means is you'll typically see a permanent standard come about 6 months after the emergency temporary standard. Now, I say in practice, but in actuality, we don't have a lot of history with emergency temporary standards, and I'll talk about it here in a second. So to promulgate an ETS, OSHA has to determine that workers are in grave danger, which is an important phrase, to exposure to toxic substances or agents determined to be toxic or physically harmful, or to new hazards, and that emergency standard is needed to protect workers. So what does it actually mean as a grave danger? Well, I would love to be able to tell you, but we don't really know. Congress didn't define it, and the legislative history is unclear. In fact, the Congressional Research Service put out a report on September 13th that says there's no clear legislative history on what Congress actually meant by the term grave danger. So we have to look back at case law, because again, this is not defined, but the Fifth Circuit kind of gave us a framework to analyze what an ETS. As you can see on the slide, there's only been 10 promulgated since OSHA was created. So this is a very unusual course of action. And this is probably because what the Fifth Circuit said. The Fifth Circuit said that the power should be delicately exercised, and only in those emergency situations which require it. So in that case, the court said the ETS, that OSHA should balance the emergency protections against their effect upon economic and market conditions. And in that case, what OSHA said they needed an emergency temporary standard is there was a pesticide that folks were using out in the fields in Florida. At that time, Florida was part of the Fifth Circuit, no longer anymore. But there was a pesticide that caused headaches, fatigue, and vertigo. But the Fifth Circuit concluded that doesn't rise to the level of a grave danger. Instead, the court said what a grave danger is a grave danger is necessitating an emergency measure should refer to the danger if incurable, permanent, or fatal consequences to the workers, not easily curable, and fleeting effects on the worker's health. So headaches, fatigue, vertigo, OSHA did not show in that case, OSHA did not show that the pesticide, if the worker stopped using it, it would have a permanent headaches, fatigue, and vertigo. And that's what the Fifth Circuit said they need to show. But the history of ETSs, as you can see on the slide, is it's uncommon. Of the 9 that were promulgated from 1971 to 1983, only one of them stood up to court challenge. 3 of them were not opposed, 6 of them were, and only one of the 6 that were, only one stood up to challenge. So the ETS it's uncommon. And so, but now that we have kind of a background of what OSHA is going to need to show, and this is a very 30,000-foot view of what OSHA will need to show to survive legal challenges that will come out after this rule is published. I want to talk about the Biden administration and their usage of the ETS. So this actually isn't, for the healthcare folks in the audience, this isn't the first ETS that came out. The first ETS that came out was in June, and it was far less onerous than the proposed ETS that is coming out now, mandating vaccines. And that ETS required healthcare or support services to do things like develop a COVID-19 plan, screen your employees before each shift, provide face masks, provide paid time off for people to get vaccinated if they want to get vaccinated, and stuff like that. And importantly, this is a very important point whenever we're talking about what's coming up, OSHA was very careful to say the ETS must be implemented at no cost to the employees. And that's important, and we'll talk about that here in a second. So while developing a COVID-19 plan, I'm not going to sugarcoat it. Developing a COVID-19 plan was somewhat of a lengthy process, and you had to, as Morgan was talking about, you had to account for the accommodations, religious and ADA accommodations, and you had to develop a test and a framework for how you're going to engage in the interactive process. It didn't, for the most part, did not require a large cash output for things like buying a test. So let's talk about now what this new ETS is. So I think, as everyone knows, this ETS applies to employers that have 100 employees or more. If you're thinking that sounds pretty arbitrary, I would agree. In a restaurant, for example, in a restaurant, you may have less than 30 employees that work at that restaurant, but they're interacting with hundreds, potentially 1,000 people a day. What makes that employer that has less than 100, and what makes those employees less likely to contract COVID-19 versus an office here in the Woodlands that has 100 employees in their office and just has common services that they touch? That is going to be a challenge that OSHA is going to have to overcome in justifying this emergency temporary standard. But regardless, the ETS requires employers to either mandate vaccines or test their employees every single week. And based on recent studies on how much a COVID-19 test costs, that could, if you're a very large employer, that could run into over $1 million a year of unforeseen costs that this ETS is going to cause your business to spend. So, and about an hour and a half before this presentation, I was talking to a friend of mine who works on Capitol Hill, and we were talking about whether the employer or the employee is going to have to pay for the test. If I was a betting person, I would say that the employer is going to have to pay for the test. So you're either faced with mandating vaccines or spending over $1 million every single year for however long this ETS remains, and if it's a rule that remains in effect forever, those are your choices. And the reason for that, as I was talking earlier, the June 10th ETS said must be implemented at no cost to the employee. In 2007, OSHA passed a rule discussing PPE. And in that rule, OSHA also said all PPE has to be paid for by the employer, or the employee could buy the PPE itself, but then the employee could retain that PPE. So if you're looking at the history of OSHA and the rules that they promulgate, most likely the ETS is going to require the employer to pay for the vaccines. And then the second part of the executive order that came out, and now the forthcoming ETS, is you have to give paid time off for your employee that chooses to go get vaccinated. That was in the June 10th ETS with healthcare facilities and businesses that provide healthcare services, and that is going to be the case for this ETS. That's not too controversial, but it is still remain to be seen what actually comes out in this ETS. So, but this ETS is going to affect approximately 80 million workers across the United States. So this is very broad reaching, and this is a very aggressive approach from the Biden administration to up the percentage of vaccinated individuals. So now let's talk about, okay, well, this is really onerous. I don't want to follow it. Well, I probably shouldn't do that. And the reason why is OSHA can issue a fine, and if you continue to repeat the fines, they can fine you up to $13,600 for each violation. So I wouldn't recommend not following it. And we'll talk a little bit about how that plays in with Governor Abbott's new vaccine mandate here in a second. But you got to be really careful, and there will be legal challenges to this. Don't get me wrong, and likely an injunction, which may stop the compliance altogether at that point. But up until that happens, you've got to be really careful, because OSHA does not have to tell you they're coming out to inspect your workplace. In fact, they rarely do. And if they find that you're violating this, then violating this new rule, then you could face pretty severe fines. The good thing about the way the OSHA Act is set up is the OSHA inspector doesn't have the final say. You can appeal it to the Occupational Safety and Health Review Commission, and they'll review the fines. And if you still want to appeal the decision, you can go up to a circuit court. Here in Texas, that's the Fifth Circuit. And if we're weighting the more employer-friendly versus more employee-friendly circuits, the Fifth Circuit's kind of is towards the top. It's more employer-friendly, but it's just something that you as the audience need to understand, that this is potentially a large fine that could be levied against your organization, and we of course don't want that to happen. So there's still a lot of unknown questions, and let's talk about those now. There's still a lot of unknown questions about what is this ETS going to look like. So from what I've been told by my friends that work on the Hill, is that the ETS is coming out this week. That's the rumor. The ETS is coming out this week, and the ETS is going to force employers to pay for the testing. That's the rumor. So if this comes out this week, you heard it here first. If not, I'm sorry, I'm wrong. So, the first, I think, a lot of the common question that we're getting is, well, how is the ETS going to calculate 100 employees? And we don't know whether it's going to be per work site or per organization. But OSHA's kind of hinted at that it's going to be per organization. So if you have, folks up in Midland and you have folks here in the Woodlands, and it adds up to be 100, it looks like your organization is going to fall under that. But again, as I was talking earlier, OSHA is really going to have to show why the 100 employee cutoff. Again, working in a restaurant, working at a gas station, any high touch, high interact, working at a clothing store, any high touch, high public interaction, OSHA is going to have to explain why those employees are not in grave danger, but the office worker over in Hughes Landing that works for a business that has 100 employees is in more danger than the folks working at the gas station. I think that's going to be a tough hurdle that OSHA is going to have to overcome, and that may end up being the downfall. The second question that we're getting a lot of is, are teleworkers exempt from the ETS? Most likely, yeah. I would say most likely, yes. OSHA doesn't have jurisdiction where an employer can't expose, control, or correct or create the hazard. So I think OSHA would say, well, if you've got everybody working remotely, you employer can't control what's going on inside of that home. So that likely wouldn't fall into that number that's counted. And then the third question is, of course, do employers need to pay for the employee's time for testing for COVID? We don't really know on that. The question is whether, driving to and from your work under the Fair Labor Standards Act, typically not compensable. Driving to and from your test site, to and from CVS or, the Woodlands football stadium, we don't know. That's certainly something that is going to be treated as a work event, but are they going to treat it as the same thing as they do with the FLSA and driving to and from work? We don't really know at this point, and the ETS will have to clarify that. And then that just handles the private employers. That doesn't touch federal contractors, that doesn't touch healthcare workers, and that doesn't touch federal employees. So along with the executive order that President Biden issued with the ETS affecting private employers, he also issued an executive order with federal contractors, more healthcare, and federal employees. And we'll talk about that next. So The executive order requires all federal employees, all federal contractors, and most healthcare workers to receive the COVID-19 vaccine. So if your business has federal contracts, there's two things that are going to happen. One, if you're trying to sign a new contract with the federal government, you're likely going to see a clause inserted in that contract that says all of my employees are vaccinated, or we have a mandatory vaccine policy, or we have testing and we're following the president's executive order. That is what President Biden has already instructed the agencies to do if you're contracting with them. But after December 8th, all federal contractors will be required to be vaccinated. All federal employees will be required to be vaccinated by November 22nd of 2021. And if not, going back to the Houston Methodist case that Morgan talked about earlier, likely those employees are going to be fired. So this is great. Our presentation was prepared. We were ready to go. And then last week, Governor Abbott issued an executive order. And that executive order was in direct response to President Biden's executive order and the forthcoming ETS. So when I saw that come out, I thought, oh, great, we can just throw up this presentation. It doesn't matter. We don't need to talk about it. Governor Abbott banned private employers from mandating vaccines. But that's actually not the case. What Governor Abbott's executive order says is it reinforces the ADA, it reinforces Title VII religious discrimination, and then it adds on what I'll call a conscientious objector to the vaccine mandate. So Governor Abbott's order says you can't compel somebody to get a COVID-19 vaccine for any reason of personal conscience, which is a new one, based on a religious belief, or for medical reasons. What's interesting about this order is there's no private right of action and there's no framework for how the government the Texas state government is going to enforce this. He says there's a $1,000 maximum penalty for noncompliance, but we don't actually know how that's going to be enforced. And there's really no clarity here on it. And also, going back to the Jacobson's case, there's an interesting question of federalism. Again, for the constitutional scholars in the audience, the 10th Amendment reserves everything not in the Constitution for the state. So the question is, who has supremacy? Is it the federal government, or is it Governor Abbott and the Texas state government? So who do you listen to? Well, I think for federal contractors and the folks that have federal contracts, the safest course of action right now is you follow the ETS. Either mandate vaccines or do the weekly testing. Because if you don't, you run the risk of the federal government pulling your contract, saying you're not in compliance, saying you're violating the ETS, and more fines. Southwest and American, two Texas-based companies, have already said that they are going to follow the federal mandate. So for you very large employers listening, most likely you're going to want to defer to the federal government mandate. And again, this can all be thrown out the window if there's a ruling from a court that says, no, this mandate is unconstitutional. Back in September, several states' attorney generals signed on to a letter challenging the emergency temporary standard before they even know what's in it. So you can expect that there will be major challenges to the emergency temporary standard. But in the meantime, it's really important that your HR folks, your in-house legal counsel, and your executives and your site managers, that they all understand OSHA and how it works, and that you have a plan. Because if this gets held up and OSHA is going out there and visiting work sites, and targeting targeting you, then you need to understand what OSHA can do when it gets out to the work site and how OSHA gets there. There's two primary ways that OSHA comes to your business. One, somebody filed a complaint, or two, they just show up unannounced. They want to do an inspection. And OSHA can do that. OSHA can show up unannounced, and they often do, and they say, there's been a report of a violation. I'm coming here. This is what I'm going to do. And so it's important for your business to have somebody trained, and I'll do a shameless plug here, that we can come out and train your HR folks to understand what OSHA can do when they get there. You have a right to say, no, we're not going to let you on. You need a warrant. That's probably not the best strategy, but it is a feasible strategy because, and the reason why it's not the best strategy is because OSHA is likely going to get the warrant. All they have to show is that there's been a workplace injury reported, an employee has filed a complaint, or somebody else, some other agency has referred OSHA to the hazard, and they can go out there. So it's important to have somebody trained on what OSHA can do, what they can look at, the scope of their investigation, and then walk around and then have that designated employee walk around with the OSHA inspector to make sure they're not exceeding their authority. And you can have a lawyer come out and do it. It can be a designated employee. HR is pretty common. Site managers for, folks that are doing drilling. That's really, really common. But you basically have an initial conference and they tell you, this is what we're coming out for. At that point, you can say, well, I need a warrant, or go ahead and we're going to walk around with you. Then they go out and they do their inspection. And they come back, and then if they're going to issue a citation, citations have to be issued within 6 months. And then you can take that citation and go back out and say, okay, I don't think this is right. I'm going to challenge it. And then you have the opportunity to challenge it, because the important thing is OSHA does not have the final say. The court or the administrative judge has the final say on whether you violated it, whether you violated a regulation, whether you violated the general duty clause, which is to provide a safe and healthful workplace. So I think regardless of what comes out this week, again, I'm betting that it's going to come out this week, you really need to have your site manager, a manager, an employee, or someone trained on what OSHA can do, because they are going to come out and make sure that you are complying with the emergency temporary standard. So with that, I think I'll open it up to questions.
Well, thank you both for that valuable information. It's very timely and it affects a lot of people. And so it's great information. We're going to shift to Q&A quickly. We did have a few questions submitted in advance, so I'm going to start with those. But if anybody watching the webinar would like to pose a question to our wonderful two attorneys who can be free legal advice, you can put that in the Q&A box at the bottom of your screen. And we'll try to get to all the questions that we can today. And if not, we'll try to have them help us send those back out to the participants. But we'll start with one really quickly. What happens if OSHA regulations or an employer mandate causes harm to an employee?
Yeah, well, so workers' compensation is in Texas and basically across the nation, workers' compensation is the exclusive remedy for a workplace injury. And I believe the EEOC has said if you're injured by a vaccine, which for the healthcare workers, I know people will say that's a low probability, but it does happen. If you're injured by a vaccine, they're going to treat that as a workplace injury. What's unique about Texas is not everybody has to subscribe to workers' compensation. If that's the case, and your business does not subscribe to workers' compensation, well, then the analysis is a little bit different and it becomes a negligence standard. And The flip side of that is, okay, the vaccine might cause the injury, but the flip side of it is my employer who doesn't implement mandatory vaccines negligent, which is the standard under non-subscriber liability? Is the employer negligent by not implementing what the federal government has told you to do? And I then contract COVID in the workplace. And that's just going to be a question, I think, that the courts are going to have to decide of what to do. And if the person can, now it's difficult to prove, but and that the causation element is going to be kind of where this all hinges. But if the person can contact trace and say, I got it from work, and you didn't follow the federal government, and you didn't have masks, you didn't have a mask mandate, or you didn't have antibacterial hand wash stations posed around your office, and you're not subscribed to workers' compensation, well, then, you're going to have to watch out for liability there.
All right. The next question is, how will boosters be categorized within all of these new regulations? For an example, if an employee considered fully vaccinated and compliant for an employer mandate if they don't get boosters?
So I'll take this one. OSHA, they should address this issue in their ETS, but the Safer Federal Workforce Task, it's called the Safer Federal Workforce Task Force. They issued some guidance in September, and they've defined a fully vaccinated individual to be either 2 weeks after the second dose in a 2-dose vaccine, or 2 weeks after the first dose in a single series vaccine. And so the guidance that they've stated is that there's not a time limit on the vaccines. There's not an expiration date. So the boosters aren't required to be considered fully vaccinated right now, but they do tell us to keep apprised of any changes with the CDC. And so they're going to update based off of the CDC recommendations.
Great. Another one that has come through is, can employers increase the healthcare costs of the unvaccinated employees?
So Delta Airlines, we know that they have issued penalties. They've imposed higher premiums for some unvaccinated employees, and the Centers for Medicare and Medicaid, they have indicated that it may be permissible to have either rewards for these wellness programs, or potentially have some sort of increased premiums, but this is going to be subject to scrutiny under the ADA, an assessment of affordability. But this can be a very complex question, and so it potentially implicates the ADA, GINA, all of these issues, and so this is something that I expect that we'll get more guidance on in the coming months as well.
Yeah, and Holly, I'll add to that. As Morgan was saying, it's going to implicate ADA, GINA, Title VII, HIPAA. Having a wellness program implicates all of those laws in the first place. So you cannot discriminate against somebody based on if they're ineligible to get a vaccine for various reasons. So you have to be really careful, and employers are going to have to be really careful, and insurers as well, that they're not discriminating against the class of people by saying, well, you have, I'm not a healthcare person, but let's say you have cancer, so you cannot get the vaccine, or you're immunocompromised, so you can't get the vaccine. Now, I'm just picking out two random things that for the folks working in healthcare that may say, well, that means they definitely need the vaccine. I don't know, but I'm just picking out two things. The law will not allow the insurance premium saying, well, those class of people have to pay higher insurance premiums. So this is what this wellness program looks like, and how employers implement those potentially higher premiums. They've got to be very careful, because they could be walking themselves right into a discrimination lawsuit.
Great advice. Another question that's come through is there a difference in how sick time is allocated for a vaccinated versus unvaccinated employee if they do get COVID?
So under the Families First Coronavirus Response Act, it did require that you provide additional paid leave if you had to miss work due to COVID, but that's now expired. So my recommendation for this is you should consistently apply whatever your leave policy is and treat your vaccinated and your unvaccinated workers the same. I wouldn't say that somebody's allocated more or less time under the current law since that Families First Coronavirus Response Act has expired.
Great. Those are all of the questions that have come through. If anybody else has any other and you want to pop it in the Q&A box really quickly, we're closing our time out here together, but if there's anything else, we can address it. Mariana, did you have anything else you wanted to add before we close out?
Thank you, Holly. I just wanted to say that we can share Josh and Morgan's contact information as well. And we will be following up, as I said, with a recording of this. So please feel free to share it with coworkers. And I want to thank everybody for your time. So greatly appreciate it. And I want to encourage our viewers to also tune in because we will have 2 more in the series. Next one is next Tuesday at 2 p.m.
That's great. Well, we want to thank Josh and Morgan. Thank you for this great information. We really do appreciate your time. We know how valuable it is. And we want to thank the partners, Stibbs & Co. attorneys. They've been a longtime supporter of economic development, and we really appreciate them. And the EDP is proud to host these meetings, and we're excited to bring you more timely information, as Mariana said, in the next couple of weeks. And if you're not a member of EDP and you're interested in joining, please let us know, reach out to us, and we'll be happy to help you with more information about that. Thank you so much for your time today, and we'll go ahead and close out a little early. And thank you very much.
Thank you all. Bye-bye.